The Honourable David Parker.
Thank you, Mr Speaker. As prior speakers on behalf of the Labor Party have already indicated, the Labor Party will be supporting this to Select Committee. Mr Speaker, the regulatory impact statement which accompanies this bill and has been presented to the House says in its second paragraph, in its pre-election policy statement on law and order, the National Party signalled its intention to introduce random drug and alcohol testing where being drug-free is a condition of bail, home detention and other community sentences. And then it goes on, and I think this is a thing that I want the Select Committee to answer for me, but by the time it comes back to the House, it says it would not be appropriate to rely on existing provisions in the Sentencing Act 2002, the Parole Act 2002 and the Bail Act 2002 to introduce an alcohol and or other drug testing regime. So the first question I have is this legislation necessary? Because it seems to me that we've got a hint in the second paragraph there that it is already permissible as a condition of bail, as a condition of a supervision order sentenced by the courts, or as a condition of parole to insert conditions as to abstinence from alcohol and to make an offender or someone who is on bail pending a charge subject to a testing regime. And if that's the case, then I would rather the government have been open about that than pretend that a great advance in the law is being made through this legislation if it was already permitted by the existing legislation. Mr Speaker, that said, there is nothing wrong in the legislation, and for that reason, or apparent on its face, and for that reason we will be supporting it to Select Committee. Mr Speaker, we have regulatory impact statements so that this Parliament makes rational decisions, so that we look at the costs and benefits. And in this regulatory impact statement, we have an assessment of what are the costs and benefits, what are the costs of a testing regime, what are the likely benefits to be, and therefore we have a reasoned position put forward by the government in support of this legislative intervention. And Mr Speaker, you would have to contrast that with the absolutely disreputable conduct that we have seen in the last day in respect of the Northland by-election, where without any cost-benefit analysis, the government, as an election bribe, and that is all it is, has said that they are going to upgrade. No, Mr Speaker, yes. With respect, Mr Speaker, I'm quite entitled to raise in this House the importance of regulatory impact statements that we have here and contrast that with conduct this very day that shows the importance of regulatory impact statements. Mr Speaker, in respect of those Northland bridges, not one of them was a priority project. Order.
The member's made a point around regulatory impact statements. Now I'd like him to get back to the bill that is under discussion and for debate at the moment.
Point of order, Mr Speaker. Are you saying that because it's embarrassing for the government to make reference...
Order. But no, and I take offence to that comment from that member, and I'm surprised that it comes from him. Please continue his contribution with respect to the bill.
Mr Speaker, this regulatory impact statement talks about the status quo, which the government says is inadequate. Unlike in the Northland situation, where there has been no reference as to why the status quo is inadequate compared with the cost of change. It then talks about what are the other options in respect of non-regulatory use of community support for testing, which would be an alternative to the testing regime that is put in place, and contrasts the costs or priorities of other interventions, unlike what's happening in Northland, where the regional roading plan is being ignored and the National Land Transport fund is being plundered to pursue an election bribe. Mr. Speaker, this is an example of good legislation and good parliamentary practice. The example in Northland is a disgrace, and members on the other side should be ashamed of themselves for what is, in my opinion, a corrupt electoral practice. Mr. Speaker, the drug and alcohol testing community-based offenders and Bailees legislation bill, as has been said by others, applies to three classes of people. People who are on bail, they're not yet convicted, they may be found not guilty, but on occasions it can be appropriate to impose a condition that restricts access to drug and alcohol as a condition of bail, and where that happens it's appropriate that we take advantage of new technologies to ensure that that condition of bail is adhered to. It's important that we don't go too far and don't intrude more than is necessary in the sorts of tests that are imposed, because these people have not yet been convicted of an offence and may indeed be innocent, and that's an issue no doubt that the Select Committee will look at in order to get the balance right. In respect of people who have been convicted of an offence and are given a non-custodial sentence, and it might be like a continuing supervision, then again the need to enforce a condition that is imposed as to maintaining freedom from drug and alcohol abuse is appropriate, and a testing regime to back that up, as has become common in other jurisdictions, seems sensible. Indeed, I think as one of my colleagues earlier mentioned in a contribution, that the findings in respect of similar provisions in Australia are that these testing regimes can make the community safer by enforcing these conditions, but also assist the offender to maintain their non-abuse of drug and alcohol to the benefit of the offender as well as the community. The third category of people where these drug and alcohol testing regimes can apply is people who have been in a custodial sentence but have been released on parole. A condition as to remaining drug and alcohol free can already be imposed, but the provisions in this Act make it even clearer that that's the case, and set out the drug and alcohol testing basis that can be imposed. Interestingly, Mr. Speaker, the bill says that the imposition of the requirement to undergo testing actually doesn't come from the parole board, but it applies to someone who is on, or can apply to someone who is on parole in respect of a drug or alcohol conviction, or has been released under Section 17 of the Act with a drug or alcohol condition. So that might say you've got to stay off the drugs or the booze, or is subject to an extended supervision order with a drug or alcohol condition. And if those, Mr. Speaker, if those preconditions are met, i.e. any one of those categories of person who is on control or release is met, then the authorised person under the Act can say to the offender, you must comply with these conditions and you must submit yourself to the testing regime. There's been some interesting technological developments which I'm sure this Select Committee will be referred to, using increasingly sophisticated technology to, on a real-time basis, ascertain whether someone is or isn't free of alcohol and or drug abuse. I suspect it's easier in respect of alcohol than it is other drugs, and that'll be one of the issues that the Select Committee looks at. And real-time notification of that screening, presumably through to the authorities, will enable the better policing of these conditions. Mr. Speaker, the Labor Party supports this Select Committee, but notes the contrast in respect of some other poor conduct today and yesterday.